Tuesday was election day. I was sitting down in New Mexico that day, but voted ahead of time. And as I came to the judicial choices on the ballot, there was my dear old friend Richard D. Green up for retention. And as you all know, Judge Green died a few weeks ago. It was a huge loss to the judiciary, and I think an even bigger loss to those of us who had been close friends with him over time. And I just wanted to recognize that there are a lot of people who may take grief for having voted for a person who is no longer with us and not even known about it. But every vote that was cast for Richard Green that day was a great vote. And I really am proud to have been able to check the box even though he's gone. And I hope whatever message comes out of that, as people are considered to succeed him in this position, because Richard really is irreplaceable, that there might be some message in his vote tally that day. Now, with respect to the federal courts, we too are Article 3 of the Constitution of the United States. And that creates the Supreme Court and such other, as the language reads, lesser courts, as Congress may from time to time see fit to create. And so the U.S. district courts were created as Article 3 courts, and I'll explain more of that in a moment as well. Ultimately, some years later, the U.S. Court of Appeals were created to fill that space between the trial courts and the Supreme Court. And over the years, a series of enactments have allowed the Supreme Court to limit certain types of cases that it will hear, while it actually has original jurisdiction to hear certain kinds of cases as well, meaning to actually handle the trials of those cases. Article 3 judges, and those include the Supreme Court justices, the U.S. Court of Appeals judges, and the U.S. district judges, have two characteristics that set them apart from the other judges. And that is, first of all, we are appointed for life or until we abuse the good behavior requirement, whichever occurs first. My old colleague, Wes Brown, who died earlier this year at the age of 104, said that he felt very grateful that they never got to the good behavior prong with him. He took it seriously. And the other thing that sets us apart is that our pay cannot be cut. And the whole purpose behind this, if you get back to the Federalist Papers, is to make us immune from the kinds of pressures that can be brought on judges who serve to some extent, greater or lesser extent, at the whim of the people. And this has been so important for us over the years, and it certainly doesn't insulate it, nor would I expect it to, from hate mail, hate emails, and also some very wonderful letters of support over decisions that we've been involved in from time to time. But at least we can't get pressured to decide a case one way or the other, either through money or fear of being removed from the bench. As most of you know who have watched some of the Supreme Court Justice confirmation hearings, situation's pretty much the same for all of us that are at the Article 3 at that level. We are presidential appointees, and we all have appeared before the Senate Judiciary Committee and testified. We get voted out of committee or don't get voted out of committee, as the case may be. And one of my colleagues, who's a U.S. magistrate judge, for example, could not get out of committee and get a vote on the Senate floor because Senator Brownback refused to return the card. to allow him to go to a vote. So Gary actually had been nominated by President Clinton to the bench, but he never got a vote. Ultimately, you have to have a confirmation vote in the Senate. And once you're confirmed, then you can take the oath and assume your duties. Cases get filed in the district court. If parties wish to appeal or have the right to appeal, they go to the Court of Appeals. If they're unhappy with the result there, if the party is, there's a right of appeal in certain types of cases to the Supreme Court, but typically private parties are attempting to get the Supreme Court to grant what's called a writ of certiorari, meaning that they think it's an important issue and one that they ought to be looking at and decide. We also have U.S. bankruptcy judges. They are Article I judges, and the bankruptcy judges actually are appointed by the U.S. Court of Appeals. Their terms are 14 or 15 years. I can't remember exactly what that is. And then we have U.S. magistrate judges, and they are appointed by the U.S. district judges in their particular district, and they serve for a term of, I believe it's 7 years. Bankruptcy and magistrate pays 92% of what a district judge's pay is, and district judges at this point, you can look it up, it's all statutory, is about $174,000 a year. Court of Appeals judges are $10,000 or $12,000 a year higher than that. And Supreme Court justices are actually not much higher than that. They're up around $200,000 a year. That's the structure of the system.
Okay. I knew there's a reason I wanted to be a federal judge. You can almost live on that kind of money.
Close.
Let me just, before I turn it over, let me just kind of comment on the state court system that we have. And Judge Marten did provide you with a handout, I believe, on that we just gave to you with regard to the federal court system that is very helpful. I believe that's off your website. And in your original materials, we have this little box diagram to help you with understanding the Kansas court system. As we start from the bottom, we start, of course, with municipal courts, which would be your city ordinance violations. We have approximately 250 municipal courts in our state. And they do a ton of business, primarily traffic and misdemeanor offenses. Then we go to the district court of Kansas, and these would be the trial courts of Kansas. We have about 163 district judges in Kansas. They're comprised of 31 judicial districts and within the 105 counties of our state. District courts will handle civil cases, and they will handle criminal cases. When you think of a district court, really, both in the context of what Judge Marten was saying in the federal context or in the state context, these are the people that have the trials, who listen to the witnesses, to assess credibility, make decisions. They really are where a lot of the work of the Kansas judicial system occurs. And in Kansas, they handle both civil cases and criminal cases. Some jurisdictions, like in Johnson County, for example, they'll separate the courts into various courts, family law courts, civil courts, criminal courts. Other state district courts in the more rural areas of our state will do it all. District courts also can take appeals from the municipal court. And this is a little bit of an odd quirk that I'll just throw out to you because it does come up, where people can be, for example, in a criminal case, convicted in the municipal court. They will appeal to the district court, and the district court will give them a brand new trial, regardless of the fact that they were convicted below. you give them a new trial, and if they get convicted there, the district court then can go to the Court of Appeals. So we have probably, in 8 years, I think I've had about 5 municipal court appeals involving a traffic ticket or something like that. So those are always entertaining. With regard to the district court, if you don't like what happened at the district court level, you can appeal, and you should appeal, to the Kansas Court of Appeals. Now, we have currently 12 judges, although we're slated for 13. We generally, the general rule here is that if you have the right to an appeal, we have to hear it at the Kansas Court of Appeals level. We also review administrative actions from the various agencies, tax court and Kansas Department of Revenue, things like that. We will review both civil cases and criminal cases. We sit in panels of 3. They mix and match us. And one unique aspect of the Kansas Court of Appeals is we're a traveling court. We're kind of blue collar. We go around the state, and next week I'll be out in Norton, Kansas, which I understand is 6.5 hours away from Topeka. So that's how far we go. And that actually was a commitment that Chief Judge Green made, and it's a commitment that we would visit all 31 judicial districts throughout the state by the end of this year, and this month, the month of November, we will do it. Supreme Court, there are 7 justices of the Kansas Supreme Court. They have original jurisdiction in very serious matters, typically your first-degree murders, treason, the most serious matters will go directly to the Supreme Court from the district court. And there are some other that I really don't think we need to mention. One thing that they do specialize in is they review our opinions with the Kansas Court of Appeals. So if you don't like what we did, you need to file a petition for review with the Kansas Supreme Court, and they will review it and decide the case. I think under our latest statistics, less than 3% of our court's decisions have been reversed or modified on appeal on review. Of that 3%, I think 2% were mine, but no reason to get into that here. With regard to the Kansas Court of Appeals, I should mention that we handle about 1,500 cases a year, appeals every year, and that requires our judges to write individually about 80 to 90 opinions each year. And generally, we are able, from the time you file an appeal with the Court of Appeals to the time you get a decision in written form, is generally about a total is about a year, which is a pretty good rate. Most of our opinions, the vast majority, over 90%, are filed within 60 days of the hearing. So we try to expedite those types of cases. So that just gives you a rough idea of the Kansas state system.
My piece of this is going to be just to talk briefly about some of the observations I've had looking at both systems, both as a journalist and now shortening my career as a practicing attorney. And I want to say I'm very grateful to get the invitation from my couch to be here and humbled to be among such a great group. My experience as a reporter, I was talking to Carolyn Trowbridge, my former boss, a bit ago, that I feel like I've been out of the game for a little while, so there are a lot of things that have changed since I've not been a reporter. And at the same time, starting out in the legal profession, many years with much more experience. But having been on both sides, I guess I feel like I can share somewhat of a unique perspective. And I think, one of the things that you've probably noticed if you've covered the courts, or that you've sensed if you've covered the courts here in Kansas, is there's, in terms of the differences between the state and the federal courts, you may have felt at times, if you've gone to cover something at the federal court, I remember having this impression, that it was much more imposing to try to get in the door of the courthouse. The security is different, it's a different feeling. You have the county sheriff in your county who's in charge of the court security. Certainly that's a big difference. And it can vary so much around the state and even within one judicial district from county to county at the state level. Whereas I think it seems to be more uniform at the federal level. And, I remember being very surprised that I couldn't bring my cell phone into the federal courthouse. When, at the time in Douglas County, we didn't even have metal detectors at the front door of the courthouse, which was a big issue back then, and that's since changed. But, and again, just an example of the difference. I think it was 2005 or 6, I covered a trial in Douglas County that was broadcast or recorded, video recorded from gavel to gavel, so to speak. It was a murder trial there in Douglas County, and so we were at the state level doing that, whereas it's been a much longer road to get to the point of getting cameras into the federal courts, as I'm sure you're aware. And my understanding is that that pilot program is up and running, and I imagine that's been discussed at earlier times today. So just, I guess, kind of comparing and contrasting, those are just some initial observations that it may seem at times, because you have to go to Wichita, Topeka, Kansas City to get to the federal courthouse, not quite as familiar and maybe not as open and accessible if when you're looking at it from outside as your county courthouse. But I don't think that means that that's necessarily ultimately true. I think there are ways to go about it where you're getting a familiarity with what's going on in the federal system. Whether it's hard to make a trip down to the courthouse every day and hang out and talk to people, which is such a great way to get to know what's going on. Talking with the court security officers and everything like that. Talking with the administrative assistants, which is an amazingly good way to get to know what's going on. But by monitoring PACER, the records access to federal court records through PACER is very good. And so it's possible to kind of keep tabs on what's going on. The other thing I would say, just in terms of what they share, what the two systems, the federal and state system share, that I maybe wish I had appreciated more as a journalist was a couple of things. There is so much discretion at the trial court level. It's amazing. And I remember having the thought when I was covering the court, if you're the district court, you're the trial court, you just apply what all the appellate courts say the law is, you apply these Supreme Court decisions, and you're good to go. And then it just kind of goes up if there's an issue to appeal. And having seen things going through law school and coming out into practice, it is just amazing how much discretion there is at the trial court level. The appellate courts get involved when there is a question of law. The law is written a certain way, and they are the ones who need to do the wrestling with that language and figure out, well, what did the legislature mean when they said X, Y, and Z? Because as we all know, one word can have so many different meanings. And so, whereas that is the burden for the appellate court judges to wrestle with, at the trial court level, it's much more of a kind of I don't want to say the word primal is what came to mind, in terms of looking at people and evaluating their credibility. I mean, a judge could, based on what they think about a litigant's counsel, a witness, they could do any number of things in any number of situations. So I think to kind of appreciate that, and when it comes to fact finding, I mean, they're the ones who are there in the courtroom and they're seeing this going on, they're seeing these proceedings from day to day, and at the end of the day, the appellate court is going to be very, very unlikely, except in special situations, to want to second guess what the trial court concluded as to the facts, what actually happened. And so I think just appreciating that they have at that, where I think most of you probably will be doing your work at the trial court level, there's so much discretion in terms of fact finding, evaluating credibility, managing the proceedings. Are you going to let a party do this procedural thing or that procedural thing, or maybe you're tired of that party's counsel and you're going to give them a shorter leash. And in terms of just the control of the courtroom, media coverage and things like that. And so I think just to be aware of that is something very important. The other thing I would say, and this goes to both the federal and the state courts, I being no longer a journalist, there are times when I miss it because despite what a lot of people think, I think people really like journalists. I think people really like reporting, especially around the courthouse. You go hang around the courthouse and talk with the clerk, and this could be at federal courts or state courts. You talk with the people in the clerk's office, you talk with the security officer. Oh, what's going on? They see you coming, you're the one who knows what's happening. The judges that I've gotten to know, I can't speak for my esteemed colleagues on the panel, but I think kind of like chatting with journalists and figuring out what's going on. They can't talk about the cases that are pending before them, and I think it's tempting to want to call up the judge and, hey, well, why did you rule this week? And I may have done that once or twice, unadvisedly.
How'd that work?
Not very well, but the thing is, and that, again, I didn't maybe understand, they can't. I mean, they can't talk about it. It's an ethical consideration for them, and so if they're doing what they're supposed to do, they're going to tell you, they can't talk about it. But coming back to the point, you have such a unique role, and I just want to say that, being out of it, I look back and I think, sometimes I find myself saying, oh, that's a story, let me be a story. Okay, well, I can't pursue the story because I'm now bound by, I'm representing my client. It is wide open in terms of what you can pursue. And in looking at what's going on in your courthouse, whether it's the county courthouse or whether it's the federal courts here in Kansas, to think about this, that our courts exist, our legal system exists as a reflection of our values as a society. And it's at a certain level, we've said what we think is right and wrong. And it's expressed in statutory code, and the judges are overseeing disputes regarding the meaning of these codes. The appellate courts are interpreting what these codes mean. You, as observers, can see this, and if you are only thinking about it in terms of, well, how does the proceeding come to an end and what was the outcome, maybe you might miss a bit of the kind of the values. What's the bigger picture of the values that this whole proceeding expresses about our state and about our society? So in terms of thinking about stories, when you're covering court proceedings, what is that next step beyond, the gavel coming down at the end of the proceeding? What does this show? Because at bottom, really, the legal system reflects our judgment about what's right and wrong.
I was just going to mention my one practice pointer of the day is, having been a former prosecutor, I really think if I was a journalist, I would make one prosecutor in a courthouse my best friend, because the prosecutors know what's going on even more than the clerks or the administrative assistants. The prosecutors generally have the burden to present evidence. So if you don't want to go to a hearing that's going to last 2 minutes and just be a continuation of a hearing in a couple months, get with that prosecutor and they'll be more than happy, if you get the right one, to give you the lowdown. We're going to present evidence on the suppression motion. It's just generally I can fill you in on what's going to go down probably. They're more than happy to do that. It's off the record. And it might help if you put the prosecutor's name in the paper now and then. But I do think that they're important to give you the information that you need so you don't waste your time, because they're the crux that kind of makes at least the criminal justice system on the state level work. Okay, any questions about the structure of the state system, federal system? If not, we're going to move to the next topic, and we'll turn it over to Judge Marten with regard to the process for selecting state and federal court judges.
I think on the federal side, there are about as many stories as there are judges. Federal district appointments traditionally have been very political. And depending on the time and history that we're talking about, it's been more so or less so. The makeup of the congressional delegation is going to be significant. Court of Appeals judges have been less political, and Supreme Court justices, of course, so much time and effort is spent in screening folks for those positions. You see what that confirmation process now is all about. Although, frankly, there have been Supreme Court justices in the 20th century that were nominated one day and confirmed the same day. I mean, the process for confirmation, they say it all started with Robert Bork. I'm not sure that that's accurate, but in any event, everything that can possibly be uncovered is uncovered. It's played out for everyone to see. Fortunately, that doesn't happen as much at the district level. I can tell you a number of my colleague stories, but what it all really boils down to is what Justice O'Connor of the Kansas Supreme Court and later Chief Judge O'Connor of my court said: you have to be the right rat at the right hole at the right time. And in my case, in 1994, and I'm a lifelong Democrat, but never an activist in the party, at a time when friends were stuffing envelopes and had the ability to write big checks. I didn't, and I was coaching kids' Little League baseball teams and that kind of thing. In 1994, when the Republicans took control of the Senate, suddenly it became not a detriment not to have been politically active, and it actually became something of a detriment to have been. And if that had not happened in 1994, I can assure you that Lee Kinch would have been sitting here with you today, who had been chairman of the Sedgwick County Democratic Party and had been an activist in the party for a long time. Lee probably would have had some real difficulty. I think the president at the time was looking for somebody who would not raise a lot of opposition. I just tried to be a good lawyer in McPherson, Kansas. And as it turns out, Senator Dole and Senator Kassebaum could not have been kinder to me, a lifelong Democrat, than they were. They championed my nomination. They appeared with me at my confirmation hearing. And Senator Dole arranged for an early confirmation hearing. And so from nomination to confirmation for me was a period of about 4 months. And that's a pretty short period of time in the overall scheme of things. I've got a dear friend on the Ninth Circuit, Willie Fletcher, who was nominated about midway through President Clinton's first term. He was carried over into President Clinton's second term and finally was confirmed to the Ninth Circuit after, it was about 5 years. And Willie taught at Berkeley, so he was not like a practicing lawyer who had clientele where he'd be up in the air. But his mother was on the Ninth Circuit, and in fact just died a couple of weeks ago. And there was opposition raised having a mother and son on the same court. Betty ended up agreeing to take senior status, and they agreed never to be on a panel together. You know, this was not a problem with the Hand brothers in New York or with the Arnold brothers, not too many years before that. But I think it's a pretty good indication of how political a lot of this process really now has become. But in our court, they are presidential appointments, some more political than others. You know, in the state system, and it's something that we always, every time Sedgwick County, for example, elects its district judges, it's one of the districts that does, and we all on the federal side, and I think my friends in Massachusetts, where their life appointments and so forth, in the state court, we just are so grateful we don't have to go through that process.
I have included a one-page that we just handed out, a one-page merit selection process for appointment of appellate justices and judges. That is for the state of Kansas. Let me just say that this system was developed in 1958 by a constitutional amendment in Kansas. Then when the Court of Appeals came into existence, and we're a statutory court, we came into existence by virtue of the Kansas legislature in 1977, they also adopted this same merit-based system. When there's a vacancy, all attorneys are notified that there is a vacancy and they're invited to apply, and the applicants then submit their names to the Supreme Court Nominating Commission, which also does both the Supreme Court and the Court of Appeals. There are 9 members on this commission. 4 are laypersons that are appointed by a governor for 4-year terms. There are 4 attorneys. And well, I should say, with regard to the governor's layperson appointments, those 4 appointments correspond to the 4 congressional districts. So you get a good feel for all around Kansas and represent each of the special needs of whatever part of the state you came from. Then there are 4 attorneys, and those attorneys are selected by the individual attorneys within the congressional district, the 4 congressional districts. There is a chairman of the commission, and that is an attorney that is elected by all of the attorneys in the state of Kansas. And all the commission members serve a 4-year term. However, they're staggered so that, for example, currently, even though Governor Brownback, who is a Republican, is going to be making some appointments, there are some members of the commission who are actually still Sebelius appointees, and there are also some that Governor Brownback has made in the first 2 years of his term. So they're staggered 4-year terms. The public is aware of the names of the individuals. The public is asked to provide comment with regard to the individual applicants. The applicants have to submit detailed information concerning qualifications and experience, provide writing samples, recommendations, things of this nature. Then each applicant is investigated by one member of the commission who goes around, and right now, for example, many of us are getting on the court, are getting calls from members of the commission saying, I'm investigating X person, and I'd just like to know what do you think of this person's legal qualifications. And sometimes they'll ask for just a number of different people, what we think. And so that's part of their function. Then at the end of this process, they are interviewed by the nominating commission, by the entire nominating commission. And those interviews are open to the public. The nominating commission then makes its selection, and they will send 3 applicants to the governor, and the governor has 60 days in the case of appellate judges or justices to make a selection from those 3 names. Supreme Court justices then have to stand for retention every 6 years. Court of Appeals judges have to stand for retention for the public for every 4 years. As just a newsworthy note, currently the Supreme Court Nominating Commission is considering applicants for 2 Court of Appeals vacancies. Judge Marquardt from Topeka is retiring in January, and Chief Judge Richard Green, as mentioned before, passed away. And so there are 2 vacancies on our court. Now, I learned from reading the newspapers that in the first couple weeks of January, the governor and the legislature are going to be proposing to do away with the merit selection system for appellate court judges in Kansas. We don't know exactly what that will take the form of, whether it's election of appellate court judges, or whether perhaps more likely that it would be a federal model where the governor will pick whoever the governor wants to pick and then submit that name for Senate confirmation. But that is something that apparently is going to happen rather quickly in the legislative session, so stay tuned for that, and we'll see what happens. I can tell you the Supreme Court Nominating Commission is meeting next week, and by Wednesday, we will know who the first 3 finalists are for Judge Marquardt's position. And then a short time later, the way they're structuring it, we will know who the 3 individuals are who are going to be submitted to the governor for Chief Judge Green's position.
Is this microphone working first? That's okay. I think the little I can add on this point, being only one of the 3 who has never been selected to become a judge, it would be just to talk a bit about what I've seen on this front. If you ever want to have some really bad TV footage, a really boring, visually boring story, go to one of these meetings of the district court nominating committee in your district. And I say that kind of tongue-in-cheek because it really is. I think I sat in on 2 or 3 interviews when there was a vacancy in Douglas County 4, 5, 6 years ago. And it was, you're not going to get great visual images out because it's a bunch of people sitting around in the room asking very interesting and important questions, though. And if you go and get to know these people who are involved in this nominating process, you're going to get to know the people who know what's going on beyond just that. I think it's a real important. I don't know if any of you out there had vacancies and covered this process of appointing a new district judge. It's kind of one of those things that's easy when it comes up to just ignore because it's, or not ignore, but kind of not follow very closely just because a lot of it's happening behind the scenes, so to speak, in terms of preparing for these interviews and whatnot. But I think, to get to know the people who are involved in that process is a really valuable thing, and they'll be people who will be able to tell you so much more else about what's happening out there. The other thing that's interesting, regarding retention elections, we've had, when I was in Lawrence, there was what I recall to be one of the few efforts to unseat a sitting judge, and there have been others, but it was a very interesting process to watch, and in the end it was unsuccessful. And I know it was probably very, very difficult for the judge that was involved and for the community as a whole. But it seemed like, in retrospect, that maybe it was an opportunity, too, to do some educating or reporting about aspects of the system that we wouldn't have otherwise done in terms of drawing some attention to, how do you decide if a judge is doing a good job on the bench? We want to keep them. And how does the process unfold? And, can you really look at a judge's record and like it's a score sheet and say, well, this person has only turned X number of times and this one's only been turned over. Is that a valuable means of assessing this particular judge's abilities? At any rate, I just thought if any of you ever have that situation and want to chit-chat about it, hit me up. But I think that's about all I can add on this subject.
I just want to follow up on one aspect, and that is several years ago, our court asked the legislature to adopt a review system, and the legislature responded to that, and we had the creation of the Kansas Commission on Judicial Performance. And what that did was, it was very professionally done. They would send out questionnaires to all the attorneys on both sides of the appeal and ask a series of questions, 2 or 3 page questions with regard to legal knowledge, demeanor, and things of this nature. Then all of those responses to the questionnaires were compiled, and each judge, right before the retention election, was evaluated both on the Supreme Court, Court of Appeals, and district court judges were evaluated. As of 2 years ago, our court had 92% of those surveyed said that the Court of Appeals judges should be retained. So these are prosecutors, These are defense attorneys. These are plaintiff's attorneys. These are defense civil attorneys. All of these people, and 92% said that our judges should be retained. The nice thing about that is newspapers would pick up on these, and there's a website, and you'd pick up on these, and then you'd write in your endorsements or recommendations, you'd say, well, this judge has got a low score, this judge has a high score, which is great and was very valuable. Well, we don't do that anymore because the legislature no longer funds that program. So that is the reality that we have in the current system as far as evaluating judges. You really have difficulty evaluating appellate court judges at the current time. Any questions about? Yes.
This is in regard to the appointment process. You want me to wait? In regard to the appointment process, mentioned how political it is, what's really not being addressed in the current system whereby judges are decided upon?
You can handle that. Your Honor.
Thank you. In the federal system, particularly at the district court level, I think there's a lot of deference to the person who is nominated by the president. And I think that as you move to the Court of Appeals and the Supreme Court, there probably is more scrutiny that's involved in, for example, prior writings. If it's a state court judge who's going to the federal bench, or if a federal district judge is going to the Court of Appeals or being looked at for the Supreme Court, there's a lot more attention paid to the decisions that the judge made. There are always investigations. Judge Boozer mentioned in the state the investigations there. When you go to the federal bench, there's a complete FBI investigation where agents speak to virtually every opponent that you've ever had, judges that you have appeared before. They even like to visit with some of your clients. And so you get client permission to disclose that to agents, and they go there. Additionally, the American Bar Association traditionally has been involved in doing an investigation into your qualifications. And they have a series of recommendations that they can make. Not qualified, qualified, well qualified. And there may even be an extremely well qualified. But the fact is that by the time that you get before the Senate Judiciary Committee for confirmation, there are just about every question has been addressed. And at that point, a lot of the political stuff that began, that started the process, has been eliminated. Because I think we can all name at least a half dozen people whose names were put up, perhaps as a favor to someone that they've done a lot of work for politically, and they have been either asked to withdraw or have been told that their name is going to be withdrawn from the process because they lack the qualifications. I don't know that a lack of politics is a good thing, and I don't think that having a lot of politics is necessarily a bad thing, given at least at the trial level that we actually come face to face with the people that we're dealing with, not only the lawyers, but the people whose lives we're going to affect. And I think the more that you've been out among people, the more that you've learned about them over time, the better decisions you're probably going to be able to make regarding credibility determinations. Every one of us who has made mistakes, when people appear in front of us, you get a pretty good sense, I think, of folks who are serious about being involved in some kind of rehab. That's a very long answer to a very short question, but I think that ultimately the really overt political stuff gets sifted out as the process goes on. But I'm not sure that I'd want to eliminate it completely, because there are some very, very good people on the bench who have not been great scholars, but who have been persons with enormous insight into people and who have a slightly different perspective on the law, reading one thing one way where maybe it's been read another way by somebody else. So on the state side, where there are elections, that's a whole different thing. And I remember reading in the Wichita Eagle years ago in the opinion line, we need to get judges in there who will do what we want them to. And of course, that's the last thing that anybody really wants when you cut it all away. Somebody had phoned in with that comment. And of course, the letters to the editor that you read after a controversial decision. And of course, the big problem with that, and this is not anything that we can solve, although you all can help a lot. You know, we're the only branch that has to put in writing our reasons for deciding everything that we do. And I think a lot of people just go to that last line, not journalists, but people who actually take the time to look and just see what the decision is without bothering to find out how we got from point A to point B to point C. And that's one of the great frustrations when you take a lot of time and you try to write something that anybody could pick up and read if they'll just take a little time, and they ignore all of the things that were there, the statutes that require certain things, the constitutional limitations on certain kinds of activities, and all they see is they don't like the result, and there you go. But that's just one of the things that we live with. Sadly, the state court judges, and I don't think this is true in retention elections, but when you're actually running for the job, and now that people actually can take positions on issues when they're running for judgeships, and this came out of that Minnesota case that the Supreme Court decided some years ago, I think people actually are voting for some judges because they think they will take those positions when they get on the bench. Of course, for example, in Sedgwick County, a lot of people have switched parties from Democrat to Republican just to have a chance at getting a judgeship. And it's kind of interesting as you run down at the end of the day and look at the percentages that the judges got. It appears that those on the Republican side got within 2 or 3 percentage points of each other from top to bottom, and there's the occasional Democrat that gets there, but clearly a great part of the voting public really doesn't have any idea who they're voting for. They're just associating a certain kind of mindset or approach with a party. I have serious concerns about electing judges without any of the filtering that actually occurs during an appointment process. And I feel sorry for judges who are subject to all kinds of election bad-mouthing that's unfair and in a lot of cases untrue, but I don't know what to do about that. Now, Judge Boozer, what's your position on that?
I just wanted to follow up real quickly. I don't think that the Supreme Court Nominating Commission misses anything. I mean, I went through the process 4 or 5 times before they just got tired of seeing me and finally put me on a panel. But I mean, I had friends contacted. My wife had an encounter with a wonderful Kansas Highway Patrol trooper who interviewed her, and she requested an additional interview because she just fell in love with the guy, but that's another issue we don't need to go into. Yeah. But either, depending on how the governor wants to do it, either get visited by the KBI or the Highway Patrol. They do a full workup on you too, so that's pretty good. And I can tell you, one judge who was present here in this room was of a different party than the governor who picked that particular judge. And this happens on several occasions where, you know, the politics really doesn't enter into it, unlike as much as other systems, because they're just looking for good people and they set aside the political party of the particular applicant. So that's the nice thing about the current system. And just for a point of clarification, I think in about 50% of the cases roughly in Kansas, 50% of our district judges are elected, 50% are done through a merit selection system through your county commission. So Kansas has a little strange way of doing things on the district court level. Yes, question?
We're out of time, guys.
Oh, we're out of, okay.
Well,
The potential change in the judicial nominating system, will that require a constitutional amendment or simply a change in statute?
Good question. If the legislature decides to change the way Supreme Court justices are selected, it would require a constitutional amendment. If they decide they want to change the Court of Appeals selection system, it would be by statute.